paragraph 72.3 at page 29. Where we outline what we say the issues. It's paragraph 72. We say these are the questions that arise. One of them, forget the other ones, culture and what. Ought this honorable court, therefore, I'm reading at 72.3, declare their decision of those people to be invalid, unlawful, and or unconstitutional. And then, in case somebody doesn't know what we're talking about, we put in brackets. In terms of section 81D, that would be Pacha, section 38, and or section 172(1)A of the Constitution. And we are told here that there is nowhere where we distinguish between those three things. 81D, which is Pacha, section 38, which is the Declaration of Rights, and 172(1)A, which is the Declaration of Invalidity. How can that be said when the papers are here speaking for themselves? Then, in case this is not clear, you go to, I think it's volume 9, page 1633. This is now elementary pleadings to show that this is an alternative that's being asked for. Page 1633, that's in our replying affidavit, paragraph 176. Applicant Mkhwebane says, I reiterate that I have made out a case to demonstrate that my fundamental rights have been breached and must, underline the word must, be vindicated by means of a declaratory order. And here's the important part. Irrespective of the review grounds or cause of action. In other words, irrespective of the review cause of action, which I may lose, I am saying that my fundamental rights have been breached and must be vindicated by a declaratory order. And somebody stands up here and says, these affidavits do not make it clear that there is a clear separation of an alternative cause of action pleaded in terms of 172(1)A. When that section is mentioned by name, we can't do that. We can't. At least it should not be allowed. And there are many other places. I don't want to you could go to page 16, paragraph 29, page 420, paragraph 229, page 69. You'll find I'll just do one for the sake of saving time. Page 69 at 229 paragraph. We say, violations of fundamental rights, big heading, section 10 and 34. In this section, we deal separately with the alleged violations of my fundamental rights as enshrined in the Bill of Rights, with specific emphasis on my rights of dignity in terms of section 10 and access to justice in terms of section 34. These are self-standing grounds for the declaratory and appropriate relief sought specifically in terms of section 38 of the Constitution. In other words, even if it were to be found that the Pacha grounds or principle of legality was unsuccessful, this Honorable Court will still be called upon to grant the relief sought to any other appropriate, just and equitable relief, that's 172(1)B, in terms of section 38, alternatively in terms of 172(1)B thereof. I mean, as I say, there are hundreds of other examples, but for somebody to stand here and say these affidavits do not say that do not make it clear that we are dealing with a completely different animal is just unfortunate, I think, to put it mildly. Now, it's very clear from paragraph 5 of the notice of motion, it's very clear from the passages that I've read that there's an alternative cause of action which was ignored. Then there's this thing about the attorneys. This is a complete misunderstanding of what has happened here. This is what has happened. The other side, as they are entitled to do, invoke Rule 5. I'll paraphrase what that means. What that means is that the rule is very clear. It says, just to paraphrase, if the other side disputes the authority of your attorney, then you must put a power of attorney. Fair enough. Same as Rule 7 of the Uniform Rules. Now, what do? They say, you've launched an appeal under the name of the public protector. And we want you to show us that the public protector has authorized attorneys to act on your behalf in that. Fair enough. We then come back and say, oh, you are right, dear opponents. We don't act for the public protector, but we do act for Advocate Mkhwebane. Right? And how do we show that we act for Advocate Mkhwebane? Here is a notice in terms of Rule 15 for the substitution of the public protector that you want to protect the public purse and what have you. Here's a notice so that now she's standing up on her own 2 feet to say, I'm now here as myself. If there are any costs, there'll be costs against me. So the public purse is saved, thank God. Right? Now, if the opponents wanted to invoke Rule 5, then they should issue, once that has happened, because there's now a substitution, that party in respect of which the Rule 5 was being invoked has disappeared out of the scene. All right? And if they wanted to question the authority of Ms. Mkhwebane now as herself, they should issue another Rule 5 and say, Ramushu, Twala...
But that's not what the rule says.
No, that's exactly what the rule says.
No, let's look at it.
Let's go together.
Look at SCA Rule 5.
Yes, no, let's go to it together. Where's the volume 1? Sorry, Justice Banner. I'm sorry. Yeah, let's read it together. It's Supreme Court of Appeal, Rule 5. Right. Rule 5.1, let's start there. Okay? It says, it's the equivalent of Rule 7. A power of attorney need not be filed. Right? That's the operational thing of them. But, so the statement is that a power of attorney need not be filed. But, the authority of a legal practitioner to act on behalf of any party, and any party in this case, let's say, is Advocate Mkhwebane.
The party that was on record at that stage.
No.
They couldn't purport to act on behalf of a party that wasn't on record. Surely that has to be so.
I've just accepted that. I've said that when they did the first Rule 5...
Read the rest of the rule.
No.
Let's read the rest of the rule.
You stopped me midway, so let's deal with it, with the issue that you've raised.
Who was that attorney acting for at that stage?
At that time is what I've already said 5 minutes ago.
Yeah.
They were entitled, perfectly entitled, to protect the public purse by asking for that attorney. I've said that twice now. That they were perfectly entitled to do so, and to question the attorney in defense of the public purse. But I'm saying, once it was then clarified to them that she's no longer acting for the so-called public purse, she's now acting for, she now has attorneys who are acting for her, as a human being, like you and I and everyone else. Then this is what happens. It says, after it has come to notice to any other party so acting, that's them, or with the leave of the court on good cause shown at any time before judgment, be disputed. In other words, if they now wanted to dispute Ms. Advocate Mkhwebane's the power of her attorney to act for her.
No, this is a dispute that pertains to the authority of the attorney. It's got nothing to do with her.
No.
Well, let's read the rest of the rule.
No. When it says the attorney of any party, the party means her. Okay? So
and whose authority is being disputed?
Of her attorney now.
That was at that time.
No. I'll do it slowly again. At that time, when the first Rule 5 notice was issued, it was perfectly great, legitimate, in protection of our tax. All right? That then happened. Then what then she did was to indicate, to say, I am not acting as the public protector. So you don't need the authority of Ms. Talega, I think is the public protector now, for that, because if she was insisting and saying, forget it, I don't care what you say, I might have been impeached or not impeached, but because I was the public protector when the calamity happened, I'm still, if she was taking that position, then you would have to either get a letter from Ms. Talega authorizing her to do so, or the power of attorney. But she's not saying that. She's saying, I relinquish that status. I'm throwing it away. And I'm now coming to this court as any other citizen. Now, they were entitled to say, well, even as that citizen, we want to invoke Rule 5 because we don't believe that your attorney has a power. And then the attorney would have included or did the power of attorney. Anyway, that's really what the rule says.
No, sorry. No, that's not what the rule says. I'm going to read it to you.
Okay.
You've got to, or with the leave of the court and good cause shown at any time before judgment, be disputed by notice, whereafter upon expiry of 10 days after service of the notice of the legal practitioner shall no longer so act unless a power of attorney is lodged with the registrar within that period.
Yes.
That's the rule operates absent a power of attorney on behalf of the party who is properly before the court. It operates to disqualify the attorney from acting.
Who is the party?
At that stage, who was the party?
Just the public protector. And is that party here now? No. So how could?
Well, that's precisely the point, isn't it?
Yes, but honestly, this thing is very, very simple. It says that if in other words, two things can happen, Justice Connor. If you invoke Rule 5,
yes,
the other side can say, "Oh, you got us now," and that is the end of the matter. Or it can say, "Here is the power of attorney." That should be patently obvious. So those are the two things that can happen. So if this other party was just a fly-by-night chance taker, that would be the end. We'll never hear from them again after the Rule 5 notice has been invoked. But if it is not a fly-by-night party, it will then file a Rule 5 power of attorney. This party before you does not say any of those two things. Firstly, it's not saying, no, I insist. It says, throws in the towel, so to speak, and says the authority of the public protector is non-existent. So I can't give you something that I don't have. And for that reason, the party called the public protector gets out of the window because of the failure to give the power of attorney. That could have been the end of the matter, but it was not. Ms. Mkhwebane files a Rule 15 to say, I accept that the public protector is gone, but I want to be substituted, all right? Substituted as myself into that position. Anyway, that's...
So are you saying by filing the notice?
Right, this is 15.1.
Yes. Advocate Mkhwebane was automatically substituted as the appellant to the matter, and there's no need for an application, so the leave of the court was never sought. I'm confused by the document because it says notice of application. So is there an application that this court is was entertaining, or this was a notice to say, I'm telling you that I'm now substituting the appellant?
No. There should be no confusion. She was saying, Justice Masipa, that I am conceding, okay, that the public protector, qua public protector, can no longer be the appellant. What I'm doing, and that's why I'm saying, at that point she could have made that concession and gone home. But she says, no, I am applying to this court, in terms of Rule 15.1, to be substituted. Substituted means to be put in the place of that, it's like in soccer. You substituted, to be substituted in the place of that person who has now died or gotten tired or broken an ankle if it was soccer. Okay? And that is, it can be that she takes the attitude that was sufficient. Then what have you been doing here all day? Because what we are doing here all day is to move that application, because that application can only be moved here, which is unopposed, by the way. So if we took the attitude that by simply putting the notice, what's the problem? Then what would we have been doing here all day? All this day, we've been moving the unopposed application to substitute Advocate Mkhwebane for the public protector, which I don't understand what the problem is about that.
So if that is the position, then how would they have already filed the second Rule 5 notice?
No, because they would say that you are now saying, let's say it was someone who had died. You are now saying your father or your mother has died, and you, the son, and now must be substituted to be the appellant, right? Now, we have reason to believe that even you, the son, are not properly authorized. And if they did that, they have to then issue a Rule 5, and then me, the son, I will then give them my attorney's power of attorney. It's that simple. So okay. Anyway, or alternatively, they could say, Justice Masipa, no, we are opposing your application, as they would if it was an amendment application. And then we know what would happen. But they don't do any of that. They don't oppose the application stroke notice of 15.1, and they don't contest the authority of the attorneys insofar as they are acting for Justice Mkhwebane, for Advocate Mkhwebane. Finish and clear. Okay.
Yes, thank you. Is there anything further?
Yes, there is.
Yes.
Okay. Now, My young friend for the DA says that it's not the ASLA Kejima law doesn't apply because the transgressions are not clear cut and so on. I honestly don't think I need to address that. I can just make this point, which will make it easier, shortcut, which was presented to me by Justice Mkhwebane. If you go to that rule, paragraph 47, Justice Mkhwebane, that we spoke about, which is the justification really for the entire judgment, and you picked it out correctly. What is wrong with that judgment is that, as I said, it elides actively, if I may put it that strongly, the real complaints of what we're saying were the violations. So, for example, it says we don't know why she's not she's complaining about the temporary absence of her lawyers, because after that a postponement was given. That, even if that were true, that only applies to the closing out of the lawyers on the 13th of September. They don't say anything. I mean, I don't know how wrong you can be. And the leading of a crucial witness in those days in the absence of lawyers. So how anybody can come here and say that the violations don't speak for themselves. Secondly, then there is the Dube situation. I don't want to go through that again. There is a situation where one of the people is married to the initiator. The only thing you get, they say, no, she's not a complainant.
But haven't you covered all of this in your earlier address?
No, I haven't. I'm saying that the people who are allowed to stand here and say that the violations are not as I'm describing them. And therefore, the Kejima principle doesn't apply. So I have a duty to my client to reply to that.
Fair enough, but not to cover argument that you had addressed in your main address. In other words,
that's exactly what I'm not.
If you just focus on a reply to what was raised, the submissions that were raised, without necessarily repeating what you had said earlier.
Well, I can't do that. I'm unable to do that.
You're not
I don't know how to reply without replying, without saying why it's wrong what they said.
Okay. Yes, Kelly.
Yes. Maybe I don't understand the request. The only way I can reply to what they were saying is to demonstrate that they are wrong. And I was busy doing that.
Yes, Kelly.
Right. Now, I was saying and I did this deliberately, as I said. I could have stood here and give you the 17 violations. I think 14 for the chairperson and 3 for Mr. Milham. But I decided that it would not be necessary to do that. I'll use one of each. And all I'm saying is that even if you take it at that level of the one of each, the closing out of the lawyers and the patent conflict of interest, no one should be allowed to stand here and say that the violations in a constitutional state don't speak for themselves. That's all she's saying. Ms. Mkhwebane is simply saying my rights were violated at that point, as Justice Kruger put it, at the source of the violation. that submission was completely wrong and not supported by anything in front of you, then we are in the heartland of the Bijima principle. That's really the only way from here. That if you accept that, because that's what Bijima says, it says if the violations are as blatant and glaring and clear-cut as in this case, then you can't deny the applicant of their rights. And I want to go further to say you can't do it on a technicality. Whether that technicality is mootness, whether it's rightness, whether it's delay, whether it's substitution for that matter. You can't, that's the gist of what the Bijima principle is. Then, finally, my learned friend doesn't, again, it says something that's startling. Section 15.1 is there to invoke the 173 powers of this court, right? The inherent jurisdiction, and I think to his credit, Mr. Jamie acknowledges that. But in the same breath, he says that doesn't apply to this court. How can that be? Section 173 states that it applies to this court, of the Constitution at least. So, yeah. Just in case there's any debate, it says 173. The Constitutional Court, the Supreme Court of Appeal, that's here, and the High Court of South Africa, each have the inherent jurisdiction to protect and regulate their own process and to develop the common law taking into account the interests of justice. So, to the extent that the powers in 15.1, which Erasmus says, are a mere codification, if you like, of the Section 173 powers, of the inherent powers, and the simplification, because Erasmus says that that rule does two things. It asserts the inherent power and it simplifies the process. To that extent, then surely it must apply to the High Court, the Supreme Court of Appeal, and the Constitutional Court. That's so you can't again stand here and say that Rule 15.1 doesn't apply. Yes, it is part of inherent jurisdiction, but it only applies to the High Court. Where does that come from? Because the inherent jurisdiction now is no longer encapsulated in the common law, it's encapsulated in Section 173, which mentions this court by name. Yes. And it all really comes down to one final submission, which is this. That when the Constitutional Court says that this court, or any court for that matter, can overlook all these technicalities, whenever it is called upon to perform its most glorious duty, which is to vindicate the Constitution, and to assert the rights, human rights of persons who come here. That cannot be something that court said lightly. It can't be. Because as lawyers, when you read it, it almost offends yourself. How can you be allowed to get away with undue delay, mootness, ripeness, and all these things? But that court made that statement with its eyes wide open, so that men and women who want to assert their constitutional rights and use the Constitution as their shield instead of self-help or violence or all sorts of things. Their path to doing so must be opened up as wide as humanly possible. And that's why that came from the Constitutional Court now recently, but it came from the drafters of our Constitution in 1996 by the sheer expedient of using the word must. That's what they wanted to achieve. And to the extent that there was any doubt, that doubt has now been removed in Gijima, in Asla, in Notyawela, and a long line of cases. So that justice must be done, and a person must be allowed to vindicate their constitutional rights. Not a myriad of technicalities thrown left, right, and center, and upside down, in medias res, mootness, substitution, this and that. That's exactly what that line of cases say should not be done, justices.
Yes, thank you.
Sorry, just one thing about the cost thing. I don't have to address that because I think Justice Panem has addressed it correctly, except to just make the point that you can't have a circuitous argument that says don't substitute but marked with costs. Secondly, it goes again to Justice Masika's question. The concession, quote unquote, or the throwing of the towel to say this is not the public protector that is here, ipso facto means that Advocate Mkhwebane, as the substituted party, the cost must be against her personally anyway, because she's the only person who is before you. So there's no question about the so-called cross appeal. There's no one else who can bear the cost of this appeal except Advocate Mkhwebane in her personal capacity, because that's what she has asked you to do by substituting her. To the court, and the relief we seek is therefore that, we leave that issue of the discussion in the hands of the court as to whether the matter, if the appeal is successful, will be remitted back to the Western Cape High Court or decided here. But let me just say that the reason the record, the full record, was included in the record was so that to give the court both options. So if the court accepts at face value, as it should, in our respectful submission, that the violations occurred, then there's nothing stopping this court from saying that if the violations occurred, if they were ignored, if they were pleaded and they were ignored, therefore the court must vindicate them. There would be no need to go back to the Western Cape High Court on that scenario. But if the court says, no, we're not inclined to do that, despite the fact that it will cost money and inconvenience and all sorts of things to go back to the Western Cape, we want you to go there, that's another approach. So the matter will either end here, go back to the Western Cape, or go to the Constitutional Court, whichever way. But we plead with this court humbly that the correct, in these glaring circumstances, the correct order would be to make the declarations that are requested in terms of 172(1)(a), because there's nothing. It will never change. You can take it back to the Constitutional Court, you can take it to the Western Cape, you can take it to the Magistrates Court, you can take it anywhere. The violations have already occurred. The lawyers have already been locked out. The conflicted person, Mr. Milham, has already sat and made a decision in conditions such as those in S versus Dube. So there's no purpose that can be served by remitting this matter back to the Western Cape High Court on these facts, at least. That's the purpose.
Judgment is reserved. Court will adjourn.
He's feeling as well. How? Where's the... No, but I saw that 6 hours. I was over the one. No, but no, I'll be too tired. So we're going tomorrow. I left to fly. In fact, oh shucks, I'll check if my television is at least I can say